Hi, I'm Jonathan Eshkeri, English solicitor and Spanish abogado, practicing law in London and in Tarragona, just south of Barcelona. During the 60s, 70s and 80s, and even more so in the period between the early 90s and the crash in 2008, the purchase of homes in Spain became extremely prevalent amongst Brits. Even after the crash, there's a healthy appetite amongst Brits for Spanish property. The result is that a huge number of UK nationals now own property in Spain, very often unencumbered. It stands to reason that a proportion of those property owners incur liabilities that they can't discharge, and they may even be declared bankrupt as a result. Sometimes properties are purchased in the names of companies registered in foreign jurisdictions, such as England and Wales or Scotland, or perhaps in the name of a Jersey or Guernsey registered company. The question for the creditor, the trustee in bankruptcy, the liquidator in relation to company insolvencies, or those with equivalent authority in other jurisdictions, is how to register an interest in the asset and then realise it, if necessary, without huge difficulty, delay or expense. As many of you will already know or will have heard from others, recovering assets in Spain is usually difficult, slow-moving and expensive. It can also be difficult to identify professionals with suitable experience in the market and an understanding of your needs in terms of responsiveness and competitive pricing. I'd like to take you through the broad steps necessary to register an interest in Spanish assets, with a particular focus on real estate, and then consider how to realise the asset successfully and cost effectively if needs be. If you're watching via our website, www.solicitorsInspain.com, then further down the page you'll find some bullet points setting out each step, and below that a transcript of everything I'm saying in this video, in case you find that easier to follow either now or later on. Of course, I'll be more than happy to speak with you either on the telephone or in person about a specific matter when I'll be able to provide you with a lot more detail. The starting point will be registering your interest in the Spanish asset, and in order to do that, we'll need either a court order of some sort or the consent of the owner of the asset. This is one of 3 videos considering how to realise Spanish assets and how to secure any debt owed by way of a charge registered against a Spanish asset. In this video, I'll be considering what a trustee in bankruptcy or liquidator, or the equivalent in any given jurisdiction, needs to do in order to register his or her interest in a registered asset in Spain. I'll be focusing on real estate rather than personalty, as it's far more common that Spanish assets in a bankruptcy estate are immovables. I'll also limit my consideration of the process to the realisation of real estate in an English bankruptcy, although the same principles will apply to any insolvent liquidation of assets. Upon the court making a bankruptcy order in England, the official receiver becomes trustee in bankruptcy. By certificate of appointment, the official receiver may appoint an insolvency practitioner as trustee in bankruptcy. As the legal interest in the bankruptcy assets will vest in the trustee from the moment the bankruptcy order is made, it's from that point that we can register the trustee's interest in the Spanish asset. Currently, the process is governed by the provisions of Regulation 2015 of 848, whereby the Spanish property registrar must recognise insolvency proceedings of member states of the EU upon receipt of a bankruptcy order and a certificate of appointment, if relevant, both duly legalised by having the Hague apostille attached to each of them. That may all change with the UK's imminent departure from the European Union. If it does change, then the process for registering the trustee's interest will probably become slightly more long-winded. That said, whatever the process, what is clear is that in addition to a bankruptcy order and a certificate of appointment, the only other documentation that may be required in order to register the interest of a trustee in bankruptcy against the Spanish property is an affidavit of laws setting out the effect of the bankruptcy order and any certificate of appointment, and a power of attorney authorising the trustee's Spanish legal representatives to submit to court an application for the recognition and enforcement of the bankruptcy order and certificate of appointment. We already ask a trustee in bankruptcy to grant us a power of attorney at the outset, as in addition to registering the trustee's interest in the Spanish property on the property register, we may need to apply for a Spanish tax number for the trustee. And in due course, we'll need to sell the trustee's interest in the property, for which we'll also need a power of attorney. It's useful to have a power of attorney in place at the outset, even now, as it enables us to give the property registrar confidence that we're in fact acting for the trustee. So even after Brexit, whatever its terms, the procedure for registering a trustee's interest in Spanish real estate will remain fairly similar, albeit a little bit more long-winded. When engaging a Spanish lawyer to act on your behalf in relation to a matter before the Spanish courts, you also need to engage a court procurator. A procurator is an administrative intermediary in the Spanish civil and criminal justice system. You may ask yourself why you'd need to grant a power of attorney to engage a lawyer and a procurator to act on your behalf. It's because in Spain the courts won't recognise a lawyer's standing, or indeed the standing of a procurator, unless the client has granted each of them by power of attorney full authority to litigate on their client's behalf and to do everything in relation to the litigation, including but not limited to reaching a settlement, receiving funds, appealing decisions and making applications to recover costs. These are extremely broad powers, as you'll recognise, particularly when contrasted with the position in the UK. Notwithstanding the very broad authority conferred to us by a power of attorney for litigation purposes, at E&G Solicitors in Spain, we'll only ever take steps on your behalf once we've set out the options available to you, advised you as to each option, and have received from you your written instructions as to the steps you want to take. Once the trustee's interest is registered on the property registry against the interests of the bankrupt, only the trustee or someone acting on his or her behalf can sell or mortgage the asset. If the property is owned in the sole name of the bankrupt, then provided the property is not occupied by anyone, the trustee can take possession and sell it without further delay. The question of possession is determined by whether anyone has their possessions in the property, not only if someone is physically inside it. So if the property is furnished, then there's a possibility that it's occupied. If the trustee takes possession of an occupied property without permission, then the person or persons entering the property without permission are committing a criminal offence according to Spanish law. So, if the property is occupied, then we need to obtain a possession order from the court with jurisdiction, that being the court that made the bankruptcy order. If the property is jointly owned, then the position is more complex. We'll need to agree with the joint owner either to buy the other half of the property from the trustee or to sell the property on the open market together with the trustee. If the joint owner isn't prepared to do either, then we can help the trustee to obtain an order from the court that made the bankruptcy order, authorising the trustee and those whom he may so authorise to sell the joint owner's interest in the property and hold the proceeds of sale for the joint owner, subject to any other terms of the order. If for any reason that isn't possible, then the trustee will need to make an application to court to dissolve the joint interest in the property. Once the Spanish court has made an order to dissolve the joint interest, the trustee can apply for the property to be sold at public auction. A date will be arranged for the public auction of the real estate in question. This means that an auction will be arranged for that asset only. Any interested parties will need to attend the auction, which will almost always take place in an office in a court building and will often be run by 2 civil servants. No judge will be present. There's also an option to attend an auction by way of the court's internet portal. Anyone attending to bid will need to have either deposited funds with the court amounting to 5% of the auction value of the property, or deposited a bank guarantee with the court to the same value. The auction value of the property will be determined by a valuation provided by a court-appointed valuer, upon application by the chargee. Anyone attending the auction will be able to bid for the property. The lowest price at which a bidder will be able to own the property will be as little as the total value of the debt secured against the property, subject to the way in which other bidders behave, including the person forcing the sale of the property. If nobody attends the auction or nobody bids successfully for the property, then the party enforcing the charge can be awarded the property for as little as 50% of the auction value if the property is not the primary residence of the debtor, or as little as 60% of the auction value in the case of a primary residence. The property may then be registered in the name of the creditor, who'll have to pay transfer tax as if he or she was purchasing the property. It's for that reason that sometimes a creditor awarded property in this way doesn't register ownership of the property until a purchaser is identified. At ENG Solicitors in Spain, we've been helping clients to realise assets of insolvent estates located in Spain since 2004. Please be in touch with me directly for specific advice in relation to your matter. You can find my contact details on our website www.solicitorsInspain.com. Thanks for watching.